This is Session 3, Part A, Legal Aspects for SOCE311 Establish and Manage a Practice. In this session, we'll look at the law, the consequences, and some of the different types of law that applies to you as a practitioner and your business. This is Part A, Session 3, Legal Aspects for SOCE311 Establish and Manage a Practice. We start off with a quote. Very early on, 106 BC to 43 AD, by Cicero. The welfare of the people is the ultimate law. So, again, looking at the protection that is afforded to clients, to people. So bear that in mind when you are looking at your first assessment, your case study scenario assessment. So what does the law have to do with complementary medicine? Well, everything. As practitioners, we are affected by many different statutory laws, and we'll cover many of these laws from the Health Practitioners National Law, various codes of conduct and ethics, various privacy acts, anti-discrimination act, things to do with record keeping, and workplace health and safety. As small business owners, and we've mentioned this in our previous session, we have those three roles that are integrated: the entrepreneur, the manager, and the practitioner. And when it comes to the law, we are subject to laws such as taxation, ASIC, the ATO, corporations law. In terms of regulations, there is things that we need to comply with. There is common law that sets precedents. There is torts. There's the importance of our duty of care. There are statutory duty of care regulations that we need to apply to and abide by. There's scope of practices. We need to ensure that we're not negligent in the practice of what we do. In the provision of services, products, we need to comply with various competition and consumer laws, the Therapeutic Goods Act, Sale of Goods Act. So when it comes to what we do and what we practice, there is a lot in terms of legal aspects that we need to consider. The law as it applies to the natural medicine profession is not straightforward. We have a national code of conduct for healthcare workers that has been agreed to. As with all laws and acts and regulations and legal precedents, we are all presumed to have an understanding of our responsibilities and our obligations. Ignorance of the law is no excuse. So each state and territory must implement its own requirements under the National Code of Conduct. This Health Practitioner Regulation National Law is in force in all participating states and territories. The applicable legislation in each state and territory is listed here. So have a look at which state and territory that you're in and click on the various acts that apply to your specific state or territory. Have a look at it. Read up of it. Get comfortable with it. This Health Practitioner Regulation National Law confers specified jurisdictions on the National Health Practitioner Ombudsman and Privacy Commission. And there's various laws and acts that provide those requirements. And they include the Ombudsman Act, the Privacy Act, and the Freedom of Information Act. These Commonwealth Acts are modified by the National Law of Regulation to make them suitable for the National Registration and Accreditation Scheme for health practitioners. So have a look at that Health Practitioner Regulation National Law Regulation. Now, when it comes to the law, consequences, and health practitioners, this is a really key aspect that you need to understand. A health practitioner whose registration has been cancelled is forbidden to practice the profession. This means that a practitioner whose registration has been cancelled or suspended, for example in New South Wales, is automatically also banned from practicing in all other Australian states and territories. In return, a practitioner whose registration was cancelled in another state or territory is automatically banned from working in the profession in New South Wales. So your registration and the cancellation of your registration means you are not allowed to practice in your profession. So the law has significant consequences on your ability to earn an income. So it's important to abide by the various laws. Now let's go back a little bit and look at the judicial hierarchy of the Australian courts. Now, Australia has a federal judicial system and is made up of 5 judicial levels. So the lower courts to follow precedents made by the higher courts, and this allows consistency and modification. If you want to appeal, you can appeal to higher courts, and there are specializations in the hearing of particular cases and interpretation of particular statutes. Now, there are various levels from the High Court of Australia. You can read up about what they do. Level 4 is the Federal Court, the Family Court of Australia, the Federal Magistrate Court, and the Commonwealth Tribunals. Again, there's specific descriptions about what the Family Court of Australia does, what the Federal Tribunal does, who do they include. Again, of interest will be, as a business, the Australian Competition and Consumers Commission, Human Rights, Administrative Appeals Tribunal. Level 3 is the state and territory courts, and this is where you have your supreme courts or your superior courts. So they deal with civil jurisdictions and hear the most serious criminal matters. So bear this in mind when you are thinking about your case study assessment. Level 2, this deals with courts with a wide civil jurisdiction. So there are district courts in New South Wales, Queensland, South Australia and WA, where you have one judge presiding over them, and you have county courts in Victoria. Then you have your level 1 courts. These are courts with minor civil, up to a certain monetary value, and criminal matters. So local courts in New South Wales, Tasmania and WA, you have magistrates courts in Victoria and Queensland, and you may also have specialist courts and tribunals. For example, coroners, drug, children's court, residential tenancy tribunal. Again, think about how your business, your location of your business practices, how they may be influenced by the different levels of courts. Now, in terms of the principles of court proceedings, our legal system is known as the adversarial system, meaning our judges have no general power to make inquiries but adjudicates on a legal issue put forward by parties with evidence. So what's evidence? Evidence is any matter that can persuade the court that some other facts exist or does not exist. So evidence requirements change according to whether it's used in relation to court proceedings or administrative tribunals. The burden of proof differs between criminal versus civil law. In criminal law, the burden of proof must be beyond reasonable doubt. In civil law, the burden of proof must be within the balance of probabilities. So if you want to learn a little bit more about what the legal system is and some of the essentials of the law, please by all means look at the bottom of the slides, and in them there are references that you can apply to and look up to. Now, it's important that you get used to reading case law, because in your case study assessment, you'll be required to look at, are there any precedences, any case law that apply to those various scenarios. So go to austli.edu.au, log on today for legislation, case law, other information on decisions of courts and tribunals about registered health practitioners. Please also have a look at these various websites. They are very, very useful in terms of learning about cancelled or suspended health practitioners. And bear in mind, these are lists of health practitioners that are no longer allowed to practice in the various states or territories. So have a click on them, browse them, and reflect on some of the case law and the case scenarios that these practitioners have breached. When looking up case law, it is good to have the full title. If you don't have the full title, a shortened version is recognizable. You can also find case law by identifying keywords, for example, professional negligence. Using the facilities for use of words, these expressions used correctly will bring up any case law that is pertinent to, for example, professional negligence as the main issue, or where the term has been cited throughout the case. Now, you need to get used to certain definitions and certain acronyms, and this is an example of a glossary. So V means and, not versus. R stands for vagina, meaning the crown. This is often used in criminal cases. And there are also various journals, and there are specific acronyms that provide in-depth information regarding particular case laws. So be familiar with them. In terms of an activity, it's really useful if you have a read of the case studies mentioned in the 2 web links over here. So reflect on it before and after you've read those case studies. Think about what has happened to the practitioner, the consequences, the use of evidence and research. So such cases bring light to the importance of knowing your legal and professional responsibilities and being compliant with them. So have a look at these 2 case laws. Healthcare Complaints Commission versus a practitioner in 2015, August, and in September. So have a read of this and reflect on them. So now let's look at some different types of laws. Again, some basic understanding of legal law. So the system of law which developed in England is called the common law. So when it comes to common law, it's a worldwide system and operates in Australia, USA, Canada, New Zealand, Malaysia, and India. And it's common law because it's established one law, the common law for the whole kingdom. Now, we now have different types of law, from public, civil, equity, traditional, indigenous, and international laws. So public law deals with the relationship between individuals and the government. For example, criminal laws. The Crown or the state brings action against the individual through prosecution. There's also administrative law and constitutional law to deal with governments and the rights of people. You then have civil law. So this is law which is not related to crime. But civil law protects the rights of the individual. So you can bring civil action brought about by the plaintiff against the defendant. The result of this, or compensation, is usually in monetary form for an infringement of a legal right or tort. And we'll talk about torts. Civil wrongs or torts commonly occur as a breach or breaking of a contract. So reflect on occasions where there may be a breach of a contract or a law. So think about how this could affect you or your practice. You then have equity law. This is concerned with fairness and justice. So there are common law courts jurisdiction, and this means that courts must consider both common law and equitable principles and remedies. So when you think about equity and fairness and justice, think about where and how this could apply to you and affect you in your practice. Are the operations of your business, how you deal with your clients and your employees, are they fair and are they just? We then have indigenous law. There's no formal recognition of indigenous law as such in Australia, although there are recognition of the higher court of native title rights, for example in Mabo. There is then tribunals. So there are many different tribunals throughout Australia. Tribunal is a generic term for any body acting judicially, whether or not it is called a tribunal in its title. So many bodies that are titled tribunals are so-called described to emphasize the fact that they are not courts of normal jurisdiction. Tribunals are often less formal than courts and are not bound by the rules of evidence. Tribunals are both federal and state-based and can convey tenancy issues and building works to decisions on guardianship and administrative review of government decisions. So think about it. Tenancy issues, building works, guardianships. Think about and reflect on how this could affect you and your business practice. We then have local ordinances. So this is a subordinate type of law established by city councils and shires and affect practitioners, practices and other businesses. And this involves things like business planning, development, health, fire, skin penetration act, noise, parking facilities, toilet facilities, washing basins, floor covering, signage and zoning. So all of this will affect your practice. So you need to be wary of local ordinances. Now, what is torts law? Torts law is the law of civil wrongs, encompassing the obligation to avoid negligent or careless conduct that might injure someone, or the law in relation to trespass to land and goods and defamation. The four torts most likely to affect natural health practitioners are: number one, negligence, and we'll go through what negligence is all about. Trespass, defamation, and misrepresentation. So consider this and how it could affect you or your practice whenever you are practicing your craft. So let's go first with intentional torts. This is trespass to person. This could be from touching a person, whether it be palpation, ensuring that you get consent. So this is intentional torts. So there are three main recognized legal trespass. Firstly, assault. This is a direct threat, whether you mean it intentionally or unintentionally, that creates the belief in the client or the individual that they are going to be harmed, that there's imminent harm or offensive contact. This is assault. The second is battery. This occurs if the threat is carried out and the client is touched against their will. Okay, so one is a direct threat. The client believes that they're in imminent harm. And then there's battery, where the threat is carried out. And third is false imprisonment. This is deprivation of a person's liberty without the lawful justification or consent of the client or individual. Then we go into unintentional torts. This is negligence, where a careless act by a defendant that causes harm to a plaintiff unintentionally. So when you're considering negligence, there are four elements that needs to be proven. Did the defendant owe the plaintiff a duty of care? And we'll talk about duty of care a little bit later on. Has that duty of care been breached by some act or omission of an act? Thirdly, was the injury caused by the act in question? And fourth, has damage been suffered? If you want to know a little bit more detail about this, please refer to the set text Weir on Law and Ethics in Complementary Medicine. So, as an example, go to austl.edu.au and look at Civil Liability Act 2003 in Queensland and look for this specific case law. It's a case dealing with liability by a complementary medicine practitioner where a plaintiff sought damages against the negligent for spinal manipulation carried out by the practitioner. So have a read of it and get yourself an understanding of negligence, of consequences, of reading case law again. So this is Part A, Session 3, Legal Aspects for SOCE311, Establish and Manage a Practice.